My name is Florian Hoffmann. I'm a professor of public international law, human rights and legal theory at the Catholic University in Rio de Janeiro in Brazil. And amongst others, I participate in my university's Cátedra Sérgio Vieira de Mello, which is a refugee project, university project originally established by UNHCR Brazil, and which involves refugee studies, establishing refugee studies in Brazil. I have also been a research fellow at the Center for Global Mobility Law at the Faculty of Law of the University of Copenhagen, mobile, and in that context in particular, I've been developing some of the research that we're going to talk about today. Our fundamental hypothesis is that much of migration law currently suffers, in a sense, from two challenges. One is, of course, the fact that there is no comprehensive binding legal instrument in relation to mobility, but also in relation to forced migration in itself, that captures all the scenarios that in empirical reality we observe in terms of cross-border, in particular, mobility scenarios. And in the current political climate, it's also very unlikely that a comprehensive instrument will come forth anytime soon. And the second challenge then is, in the absence of such a comprehensive instrument, what happens is, of course, that international refugee law, by and large, operates around the convention system, the convention regime, which we, of course, know is limited in terms of the types of situations it captures, and then interweaves increasingly the international refugee regimes with other regimes in order to increase protection, especially international human rights, to some extent international criminal law, international humanitarian law, also national legal frameworks, etc. This kind of regime fragmentation in the area of migration/mobility has the drawback of essentially very often not capturing the much more complex mobility scenarios in which those on the move, whether they are forced migrants or other people on the move, find themselves in reality. And this is not just social reality, but this is also legal reality. So we contend that the predominant way in which we thematize law in general and migration law in particular is undercomplex. And for that reason, building on such literatures as the mobility turn in law, regime accommodation, regime complexes, regime interaction, especially regime entanglement, the topographical approach that, for example, has been pioneered by Thomas Gammeltoft-Hansen to this area, or in this area, and Nicholas Tan. And also then what we propose here, the so-called infrastructural approach to mobility law, through which we hope to better capture the very complex scenario which people on the move find themselves in normatively in today's world. Latin America has always been a migration hotspot, or has contained many migration hotspots, but has curiously been less prominent on the refugee studies, migration studies, mobility radar, in a sense, than some other regions. That is unfortunate, we believe, because Latin America has many interesting features which can inform both our conceptual theoretical perspective, but also the empirical scenario. Latin America, by and large, has strong rules of law, has strong rights-based legal systems, has traditionally been relatively receptive to migrants, to asylum. There's a long history in asylum, a pioneering role in asylum, while at the same time containing, as I mentioned, a number of acute migration hotspots, including in new areas such as environmental migration or environmentally induced migration, or displacement rather. And so given all these factors, it's an extraordinarily rich scenario in which to study how mobility law, or how rather mobility is configured, cross-border mobility is configured by the interplay of different international, regional, and national legal norms with different actors in shifting coalitions, in a sense, infrastructuring, as we call it, particular mobility scenarios. The important lesson here is also that the people on the move, the actual migrants, the displaced persons, but also other people on the move, other mobile people, from this perspective have much more agency, not just in terms of going from one place to another, but in terms of using, manipulating, interpreting in their way, and basically co-configuring the law as it works in practice. And that's what our project tries to map and tries to also look at comparatively. We believe that many mobility scenarios in Europe, especially in contemporary Europe, with current contestations of the mobility regimes, both, let's think about Schengen, let's think about the Dublin process, let's think about the general question of immigration, whether legal or illegal, and the political debate that exists amongst many member states of the European Union at this time. So we believe that the Latin American experience can quite interestingly contribute to some of these debates, not least as many of the debates in Europe, my sense is, still depart in a sense from a very static, top-down way of how the law works, how it should work, and what happens on the ground, when in reality, and we see this in many areas at the European border, including, for example, Belarus, Ukraine, etc., where mobility scenarios are much more complex than what is captured by that static view of the law. And I think a productive comparative dialogue could certainly be had between Latin America and Europe in that sense.